Well, good evening, everybody. My name is Leslie Moran. I'm a Senior Associate Research Fellow at the Institute of Advanced Legal Studies and an Emeritus Professor in Law at Birkbeck. So welcome to this evening's event, which comes under the title of Judicial Conversations. It's a series that I've been working with the Institute to promote discussions about the role of the judge. As you might imagine, the judge is central to much legal scholarship, but in a rather interesting way, the judge is also absent in lots of ways. And so this is an opportunity to ask some of the questions that have perhaps not been as diligently asked and answered in legal scholarship in the past. And I'm very delighted to introduce you to Dr. Shailesh Kumar, who is a lecturer in law at the Department of Law and Criminology at Royal Holloway, University of London. He's previously taught at University of East London and SOAS and Birkbeck. He completed his PhD in 2023 from Birkbeck and was assisted in that project by way of a Commonwealth scholarship. His research exploring the operation of the Protection of Children from Sexual Offences Act 2012, which is known as the POCSO Act, is, I think, a pioneering piece of research. And I say that for many reasons, but one of them is that it was an empirical study of an aspect of the legal system in India. And I think I'm right in saying that empirical legal research is really still in its infancy in India. So this was a wonderful initiative to promote legal research in that context. I've asked Shailesh to come here tonight, not to talk about the whole project, it has many dimensions, but in particular to talk about the role of the judge, the judicial officers in this new institution, because the POCSO reforms introduced a court dedicated to dealing with sexual violence against children. And from my understanding of research, it raises some interesting questions about the role of the judge, because it demanded the judges take a different approach in order to deliver justice to children in the context of sexual violence. So the format for this evening will be that I have a series of questions. I don't know whether we'll get through them all, but the plan is to spend about 35 to 40 minutes having a conversation between Shailesh and myself, exploring aspects of the judicial role in the context of the POCSO reforms. And then there'll be an opportunity to open up the conversation to you, for you to ask questions. And after the hour, you're warmly invited to join us for a reception, which is just down the corridor, light refreshments. Let me just advise you that the proceedings are being recorded, and the hope is that that recording will be available on the Institute's YouTube channel. So for those who want to watch it again, or for people who aren't able to make it this evening. So without further ado, let me approach my first question to you. So it's more of a request, really, rather than a question. Could you give us an overview of the main aims of the POCSO reforms?
Okay, so first of all, thank you so much, everyone, for finding time for your position to come here. I really appreciate it. Before I directly jump into answering that question, just a brief kind of arguments that I wanted to borrow from two really fantastic articles that I love, Robert Cover's Foundational Nomos and Narrative, and Peter Brook's Narrative Transactions, Does the Law Need a Narratology? It has been argued that story is an important element in law, and narrating that story is more so. How a story is told can have different outcomes. So story of privilege, story of oppression, story of persuasion. And this also reminds us of laws, particularly criminal laws, narrative of objectivity and absolute truth, but also its subjectivities. Legal storytelling, therefore, has the virtue of presenting the lived experiences of marginalized groups or individuals in a way that traditional legal reasoning doesn't. And once understood in the context of the narratives that give it meaning, law becomes not merely a system of rules to be observed, but a world in which we live. So my legal storytelling this evening, as you know, is titled Exploring the Judicial Role and its Challenging under the POCSO Act, which is, as Les pointed out, Protection of Children from Sexual Offences Act. And I will share with you the world I lived in for those 6 months of my fieldwork in India. And the world of law my respondents said they lived in. The focus would be only on judiciary because the project was much larger, included 5 other respondents groups, ranging from lawyers to police officers to support persons. But first tonight's, as in this evening's focus, would be on judiciary. Now, coming to Les's question on the overview of the main aims of POCSO reforms. So it had, let's say, 3-pronged impact on criminal law, especially in relation to the child sexual abuse cases in India. Now, as we all know, child sexual abuse is a global epidemic. And irrespective of the jurisdiction we talk about, it has remained, let's say, largely stigmatized and hidden crime or an act which is rarely talked about. Now, in terms of the reforms that the POCSO Act brought, so the first was on the substantive law and sentencing. So first of all, just to give you a brief overview of the Act itself. So this Act only targets the child sexual abuse cases in India. And it defines a child as someone who is below 18 years of age. Now it has, of course, history to it as to how this law came into being, starting from the 1989 ratification by India of the UN Convention on Rights of Children. And then, of course, several feminist movements and judicial decisions and Law Commission of India reports that actually came together then to lead to this law that came as late as 2012. So you have literally, let's say, 3 to 4 decades of historical background and struggle, feminist struggles in particular, related to specifically sexual violence, which included both adults, and of course, when I'm talking about sexual violence against adults, it primarily, going by the law, includes only women as victims, because the law is not gender neutral, as is the case in the UK as well. And then specifically to children, so sexual violence against children as well. Now, coming to the substantive law, now this was fundamentally different from the Indian Penal Code that deals with the sexual violence generally against adult persons, in the way that this was an age-specific gender-neutral law. So anyone, irrespective of their gender, can be a victim of child sexual abuse, provided they are below the age of 18. So it doesn't matter what your gender is. If you are so far below the age of 18, you can be a victim. Similarly, anyone can be a perpetrator of sexual violence against child as well. So child sexual abuse, anyone can be a perpetrator irrespective of your gender, which is again kind of unlike when it comes to sexual violence against an adult. Further then, in terms of substantive law, it widened the definition and it kind of graded sexual offenses against children. So it's not only then relying on peno-vaginal intercourse, but it has moved beyond that. And that has been another, I think, success of what the feminist movements were asking for from the legislature. There's also a bit difference in the definition of child's custody, how POCSO law defines child's custody, which has moved beyond, let's say, police, prison, and hospital. And it now includes even the home of the child as well, realizing that sexual violence against children is not only kind of a stranger danger, but has mostly been involving perpetrators who are known to the child and also as the data says, 10% of child sexual violence cases in India are committed by the family members of the child. Then you have sentencing, which is again proportionate, but also more punitive sentencing. So I think one of the rarest, again, sentencing part was the death sentence was brought in through amendment to this law for a certain kind of child sexual abuse case. So that's kind of a punitive-based approach that the state took to bring in death sentence, and of course, otherwise you have really severe punishment for child sexual abuse offences. So that was about substantial. Now, in terms of procedural law as well, you have several changes, and that's where I think the core of bringing this law is, which is around, and this was a major shift, I would say, in terms of how something like, let's say, an effective turn in criminal process. Because the argument from the National Institute, which is the NCPCR, which deals with, it's the National Commission for the Protection of Children's Rights, was that the criminal process has to be a process of healing. And that was a major shift because usually criminal process is thought of from the perspective of holding the, let's say, accused to account or doing, going through all these pre-trial, trial stages. So this was a major shift that, okay, there was an acknowledgement that because we are dealing with child victims or survivors, we need to have it as a process of healing. There are several time limits also put on in terms of in what time child's testimony should be recorded and in what time the trial should be completed. So there were strict timelines around that. So say, for example, a child's testimony must be recorded by the court within 30 days of cognizance of the offense by the court, whereas the trial must be completed within a year of the cognizance taken by the court. There were several institutions that were also added in terms of, let's say, support persons, which was never the case otherwise. Translator, interpreter, sign language interpreter, and special educator. So I'm talking about the law, and of course we will talk about the implementation and the operation in some time. Then you also have something around medical examination of child victim. So the law says that the child victim has to be medically examined as soon as possible post-incident. And if it's a female child, there has to be a woman doctor. Then you had several reforms brought to the trial stage as well. So those were the pre-trial, when child's statement would be recorded by the judicial magistrate. And then the medical examination of child has to be kind of carried out. Then you have the trial stage. And in terms of trial stage, you have then special judges who will only deal with POCSO cases. So special judges, that institution was created. Special public prosecutors. So the public prosecutor will only be dealing with POCSO cases. So again, you can see the objective was to speed up the process of disposing child sexual abuse cases in India. And it was imagined that that could only be possibly done by having this kind of a specific institution that deals only with child sexual abuse cases. That's why you had special judges, you had special public prosecutors, and you have special support persons who will only focus on child sexual abuse cases. Coming to then the evidence part of it. So you had certain evidentiary interventions as well. And what now POCSO law says is there will be presumption of guilt rather than presumption of innocence. And that was another major shift because the burden of proof then is kind of reversed and it goes to the accused rather than the state or the prosecution. There is another very interesting provision in this law, which is now, I think, being tried to be brought in the UK as well, which is around reporting and penalization of false allegations. So one provision talks about penalization of false allegations. The other talks about if any person gets to know about child sexual abuse incident, the person must report it to the state authority, to the police basically. And if they fail to do so, they will be charged for the offense of not reporting it to the police. So that means any family member, any school teacher, any doctor, anyone can be charged with that if they fail to report. And this is, again, very problematic in the context of, let's say, adolescent sexual activity. And when, let's say, a girl goes for, let's say, abortion, right? Now, of course, say they don't want to disclose it because of several reasons, but then the time they approach hospital or doctor, the law indirectly or directly puts an onus on that doctor to then report it to the police. So that's, again, a very kind of complex situation and kind of a problematic legal provision. So that's around the procedural and evidence aspects of it. There have also been several changes to the courtroom itself, or the courtroom space, let's say, and how digitization has also been brought in. So you have first special courts to deal with it. So you have special POCSO courts, which specifically deal with only child sexual abuse cases. And then, as my findings suggest, you have, because just to give you a brief, I think, overview, I think I should tell about the methodology part of it. So I focused on two locations in India. One was the state of Bihar, which is one of the northern states, and one was Delhi, which is the capital city. And I interviewed 49 stakeholders belonging to 6 different groups, ranging from judicial magistrates to special judges, to public prosecutor, defense lawyers, support persons, and police officers. Now, as I said earlier, the focus today is only on judicial magistrates and special judges form the part of the judiciary. Now, in terms of the courtroom changes, and I'll show you a few photographs as to how the changes have been brought into the trial space of the courtroom as well. Though I did not find that change across the two locations, it was mostly in Delhi, which is now, let's say, the court has become kind of a system of 3 different rooms. So it's no more one courtroom. It has been transformed into, let's say, 3 rooms that together deal with child sexual abuse cases. Do you think I should show the photographs now?
Absolutely.
Okay, so I'll just show the photographs. Has it gone on sleep mode?
That's gone on holiday.
Yeah, okay, so there you go.
Never work with technology.
Okay, so as you can see, so this one is the POCSO special courtroom in one of the districts of Bihar. And apologies for the text if you can't read that clearly. But you can see on the top, that's the POCSO judge, the special judge. You have the child witness, a separate box, along with the witness box, the usual witness box that you see in courtrooms, in trial courts. You have cameras as well, one focusing the accused, one facing the judge. But then the interesting part of this is that despite, so this was only one district. So I kind of observed 4 different districts in the state of Bihar. And this was the only district where at least you had a child witness box, where you had a one-way view mirror, which means that no one else can see the child. No, the child can, the child can't see anyone, whereas others can see the child. But then, even though the law has a provision of, let's say, having separate rooms, though of course not in the Act, this was not being followed in the state of Bihar. I will show you now another example from Delhi, where, as I said, it was a combination of 3 rooms as to how the POCSO cases were being dealt with. So, as you can see, this is the general courtroom, which is known as the POCSO courtroom, which is similar to what you just saw. You have the judge, the lawyers, the public audience. So you will have everyone here. But when it comes to recording the witness's statement, or let's say, especially the child witness's statement, which is the child survivor statement, that doesn't take place here, because the law says that the trial has to be in camera And further, this law also said that the child should not be facing the courtroom at all, nor the child should be facing any lawyer or judge or the accused. So it's not only in-camera trial, but it actually shields the child survivor from any person at all, so that the child doesn't feel at all that they are in a courtroom-like setup. So there are two more rooms to this by which the trial, or let's say the recording of child's statement is carried out. So these are two more rooms. So this is known as the vulnerable witness deposition room. And this is where you can see everyone except the audience will be there. So the accused will be behind, again, a one-sided view mirror along with police officers. Then you have the judges, the public prosecutor, the defense counsel, and you have some member of the Delhi Commission of Women, the DCW. And then, of course, you will have the deposition writer and the court staff. So only these members are allowed to be in that room. So it's in-camera trial, and that's why audience, public cannot be there. But the interesting thing is, as you can see, the child witness is still, the child survivor is not here, right? So the question is, where is the child then? So you can see there is a computer screen though here, and that's where the child's, or let's say the telecast is done, and which is where the use of video link comes into picture. And you have this third room, which they call video linkage room, come recreational room. And that's the third room where you have two kind of areas. One is the play area for the child to kind of feel relaxed. And then on the other hand, you have this other room where it's only two people who sit. One is the child victim, the child witness, and the other one is the support person. Okay? So no one else sits here. And this is like a casual room-like setup with just chairs or a couch and sofa and table. And of course, on the other hand, you have toys and books and snacks. And this is the computer screen that you see here, from where it's then telecasted to the other room, where you have the judges and the lawyers and the accused. Because we do need to remember that the accused also needs to see the child, whereas the child shouldn't be seeing the accused. So that's why the accused is able to see the child on the screen in that other court, in that other room, whereas in this room, the child has no idea as to, because the child can't see anyone else other than the support person. The support person has to be a woman, and that's in practice rather than in law. And that's another very interesting question of gender, or how gender kind of plays a role there. Because, to be frank, there's no, I think, so far any kind of research work in the Indian context that suggests that how having women as, let's say, judge or police officers or support persons is actually helping the child witness or not. And that's the final computer screen as seen in the vulnerable witness deposition room. So you have these four parts to it. So you have the judicial desk, you have the lawyers and others, you have the accused, and then you have the video linkage room, which is this room that's visible in one of the four parts in the vulnerable witness deposition room. So that's, as you can see, really is a big transformation to the courtroom trial space, basically. And the objective is to have, or let's say, give child, this kind of a space where that the child doesn't feel threatened, the child is shielded from the accused and other, let's say, courtroom kind of space. But then again, this kind of raises several questions of how useful it is and whether this kind of infrastructural changes and investment has actually worked in favor of the child.
To focus on the role of the judicial officers.
Yeah.
Who's seeing this screen with the four different images? Is this available to everybody?
So this screen, so this screen is available to everyone in this room, which is the judge, the public prosecutor, defense counsel, and the accused.
Okay, right.
Yeah. So those are the people who can see.
Okay. Well, I think we've got a clear idea of the way the space is organized and the differences between the two locations.
Yeah.
I want to move you on to ask you to focus now specifically on the reforms. You touched on some aspects of how they impact on the role of the judge.
So in terms of impact on the role of the judge, in the Indian, say, criminal process, you have two levels or two stages where, let's say, in POCSO cases, a child would interact with judiciary, so to speak. So one is in the pre-trial stage where the child's statement has to be recorded by a judicial magistrate. So that's the first stage where a child encounters a judiciary. The second is during the trial, which is where this courtroom space comes into picture, where the child, in a way, gives statement to the judge during trial, but also in a way to the lawyer and the accused. Right? So there are these two different stages. Now, in terms of role, starting from the first interaction, which is with the judicial magistrate. Now, of course, you could imagine both in law and in practice, what I found from my fieldwork is that there is no option for the child to be introduced to a court or courtroom space in advance. Because I know that several other jurisdictions have that practice if they have the child brought for trial in any such kind of space, the child is introduced, but then there was no such practice. So you can imagine child is either brought by their family members or parents to kind of navigate by themselves. And this is again where I found differences between the two locations. So where in Delhi you have much better support for the child and their family members because they are assisted by either support person or the relevant police officer to kind of bring them to a specific room, the room which I showed you, where they will sit and the child then can have snacks and all. Whereas in Bihar, that was not the case. And the child and their family members are left by themselves to navigate the courtroom, navigate the court buildings, and there is no support available to them. Now, for the first stage, during the pre-trial stage, it's the judicial magistrate whose duty it is to record this child's statement. Now, what I found, of course, from their responses that it's a very emotionally charged kind of a process, as well as a managerial process, because they first have to listen to the story that the child is sharing with them. And at the same time, because I did not find any provision to record the child's statement, so there was no use of, let's say, recording to record the child's statement. So what they had to do, they had to literally write it down, but then they were bound to write it verbatim, which means they can't change it as per their requirement or wish. They have to write it down the way the child is telling the story. So whatever the child's kind of tells the story, the judicial magistrate's duty is to write it down word by word.
So this role of the judicial magistrate taking a statement from the victim, is it unique to the POCSO system, or does it happen in other courts? So would judicial magistrates be well versed in the general arts of?
No, not really. Not really, because of course that's something distinct for this particular act, and especially looking at the nature of the child witness as well, or the survivor as well, because, and as several judicial magistrates shared with me that they were trained, but not everyone, and that's another kind of loophole that I found, but also that you need to ask a child questions in a certain way. And before that, you also need to create that kind of relationship with the child where the child is able to share their story with you.
So would the child already have been interviewed by the police?
No, it's not really. No.
Okay. So this is the first time the child is asked to tell their story.
Yeah. And then after that, of course, then once that's done, then child kind of goes back and then the child has to come again during the trial stage. Mm-hmm. And this is another kind of, because the law specifically says that the child should not be called to the court repeatedly, because this is another kind of interesting, let's say, tool in the hands of defense counsels, or even the courts which they use, which is to as a tool of harassment, let's say, that, okay, we couldn't complete the trial today, so the person will have to come again the next day. And this is kind of a harassment tool for a child survivor specifically, but then otherwise for any sexual violence survivor, irrespective of the age as well. So the next time then the child will have to come again to the court for the trial stage. So in a way, you can see the child has to come twice. Now, of course, in several cases that I found, because of lack of judicial infrastructure like this, and also lack of judicial infrastructure across different small cities specifically, the child and their family members have to travel a lot just to attend these dates or to come for these pre-trial and trial stages to record the child statement. And that becomes a hassle for them, especially if they belong to a family or they are from socio-economically marginalized communities.
So you interviewed judicial magistrates. What was their response when you were asking them about the experience of doing these interviews?
So as I said, certainly they said that it is kind of an emotionally driven situation for them, which is when they hear those stories of, let's say, sometimes 6-year-old child being, let's say, raped or being sexually violated, it's really difficult for them. So they need to emotionally manage themselves. But then more than that, they also need to, I think, in certain cases, identify and assess the capacity of the child as well. If the child has the capacity to, let's say certain things. So how they assess it is by asking them certain questions like, okay, if they can identify certain color, they will ask maybe their names, their schools names and all, and then they will proceed. So it's also kind of, I think, a relationship building, trust building with the child that they do. But then I did find that not all of them were trained specifically in this regard. So some of them, as they reported, that they trained themselves. So some said that they trained themselves by watching a movie. Some said that they trained themselves by, kind of talking to their colleagues. Though even though that there are training provisions in the law, and the different state governments are there's a mandate that they have to impart specific training.
So moving on, what about the role of the judge in the POCSO courts when it comes to the trial?
Yeah, so I think that has transformed significantly. And I would say that this is kind of a new role for the trial judges. And why I say that is because they have moved on, I think, from a passive watcher or adjudicator to now an active moderator and manager. Because this entire process, as you can see, now relies on the managerial skill of the judge, especially for the reason, because the POCSO law, in relation to the trial, says that it's the judge who will have to pass the questions to the child. So the lawyers cannot ask questions directly to the child during the trial. And it's the judge who will have to pass it on to the child. Now, even the judge in that kind of arrangement cannot ask the question directly to the child. So what's happening in Delhi, of course, it doesn't happen in Bihar, or I didn't find it in Bihar, because in Bihar, in most cases, or let's say, excluding few cases, it was always both the judges and the lawyers who were asking questions directly to the child, which was clearly violation of the law. And you can imagine it's a blatant violation of the law, because there were also instances where I observed that certain instances of character assassination and questions that were not needed to be asked from a child was being asked as well. But then in Delhi, the situation was better in comparison to Bihar. And here, as I can go back to the system, so you have the lawyers, basically, the both side lawyers, the prosecutor and the defense counsel, will have to ask the questions to the judge. And then the judge will actually ask the question, or let's say pass on the question to the support person who is present here in this room. And then the support person will ask question to the child. Now, there was a big problem with that, which was reported by the judges, which is that, and I've said 2 points. One, that sometimes they said that they have to be really balanced in order to appear as independent and non-partisan judiciary, which is because if they frame the lawyer's question in certain way, because of course you can't repeat the same question in the same manner, there's a risk of, let's say, the defense counsel saying that, oh, you are not asking the same question that I put forth. So that was one risk that the judges said that they have to be careful about. The second, they said, because the lack of training to these support persons who are sitting with the children, when they ask certain questions, the support persons actually modify it in a way that doesn't remain, let's say, the same question which the lawyer asked. So it's like a 3-stage kind of passage of the same question, and it gets transformed till the time it reaches the child, in a way. So that's another kind of a difficulty that the judges face in these situations.
Sort of carrying on from some of the comments you were making, what did you find in terms of the judicial experience? What were they telling you about that experience, about that important change in the role of the judge?
Yeah, so certainly for judges as well, as I said, the managerial role, it's also about then managing this kind of power and control in the courtroom. Because what happens in trial court, and that's kind of a coming from the perspective of social and legal culture, really, which is in trial courts, if you have a senior lawyer who is, let's say, experienced, 20 years experience, and especially because they are defense lawyers, let's say, what happens is that there is no particular regulation around training defense lawyers because they are not on state payroll. What happens is that public prosecutors, of course, they are state authorities, so they are hired by the state. There is a provision to train them with this in regard to the child sexual abuse cases, but there's similar provision is absent for defense counsels. And then there is also this power hierarchy that plays a big role in these cases in trial courts. And what happens is that the judges are unable to, let's say, intervene, and that's what was my observation as well as findings. So that they were unable to intervene, especially in Bihar, when the lawyers, let's say, ask questions that they are not meant to ask. First of all, of course, the law prohibits lawyers from asking questions directly to the child, but that was blatantly being violated. And on top of that, the lawyers were also asking questions that they were not meant to ask, let's say, around character, or let's say, certain incidents or words that a child wouldn't be considered to be knowledgeable about, right? So that was another problem and a big challenge for the judge to kind of manage and control these different other stakeholders like defense counsels or public prosecutors, supporters. And I did find that in several instances the judge was just sitting idle and didn't do anything. And I also recall there was an incident when, because the law says that you can't, if the trial goes wrong, you will have to give break to the child. And I did see once when this was a long trial, there was a, I think, 13, 14 years old girl who was on trial. And there was no break given. And the girl actually fainted right in front of me, all of us. So, of course, there was then support provided to her. But you can imagine that despite this being explicitly mentioned in the law, when it comes to its implementation and operation, that was absent.
You mentioned earlier that one of the objectives of these reforms was to enhance the speed with which justice is delivered. And I think central to your description of the reforms, in particular the procedural reforms, is that it will change the outcomes, so enhance the number of successful prosecutions. Did the judges you interviewed have any opinions about the success of those two aims? Was it making justice speedier, and was it improving the quality of the justice experience for these victims?
Okay, thanks for the question. I think when it came to speedy justice, let's start with the trial process, because that certainly was one of the objectives behind specializations like special courts, judges, and lawyers. Clearly, both the data and my findings said otherwise. So if I just share the data with you, so as I said earlier at the beginning, that the trial has to be completed within 1 year of the court taking the cognizance of the case. But only 10% of cases, POCSO cases in India, are tried within that time frame. So you can imagine each year, 90% cases are added on to the burden of the next year, new, fresh cases. And literally it has transformed so much, because you can imagine, so say for example, if this year there were 80,000 POCSO cases, which are pending trial, and if 10% cases were tried, so you have literally around 68,000 or 72,000 cases pending trial, and that 72,000 cases will be added to the 80,000 fresh cases next year, which will make it like a 2 lakhs or 180,000 cases for trial. And this is like a big multiplier. As you can see, it's like exponential growth because of lack of trial on time.
And what about the experience of justice in the courtroom? Did the judges think that these new procedures and initiatives and the changing role had improved the quality of justice?
So I would say that to a certain extent, of course, they did say yes, but then also they've pointed out several flaws in it, which is where they felt that they were confused if they were actually delivering justice or injustice. And this is where I'll point out a couple of things, especially in relation to the substantial law, which is, so the law clearly says that anyone under the age of 18, irrespective of, let's say, the de facto consent, if they have sexual activity, they will have to be charged with as an under the POCSO law. So say, for example, if you have a 16-year-old girl or a boy having, let's say, sexual activity or sexual intercourse consensually with, let's say, another below 18, an adolescent boy or girl, or even an adult, then that is by default a POCSO offense, a child sexual abuse offense. So it doesn't matter. The law actually doesn't recognize that an adolescent, let's say, whatever you can say, 16, 17, 18 years of age, can have sexual autonomy, and it actually punishes it severely. And there were really interesting incidents which the judges shared with me. So one case was where, and this is very usual, which the judge said, and this is from Delhi, the judge said, so imagine there's a couple, both, let's say both either within the age group of 15 to 18, or one is a child and another is an adult. Now, they both had consensual sex. Now, what happens in most cases, and this is where the social culture from India comes in the picture as well, which is the identity, basically. So you can think of caste, the caste system, you can think of religion, and how that plays out, because more of these cases were where you have interfaith couple or intercaste, so two people from different caste or different faith or religious backgrounds. And what happens then, of course, the family quickly then complains to the police. Now, the time family or parents complain to the police, it becomes a POCSO case, and the POCSO charge has to be put in, and then they are kind of brought into the criminal justice system. Now, difficulty for the judges then is that even though, let's say, the child is saying, who is, let's say, 17 years, 17 and a half, that, okay, it was consensually done, the law doesn't give any discretion to the judge to do it any other way around. The judge will have to punish the person.
Yeah.
That's a big point.
Well, I'm sure there's a lot more we could explore in terms of the quality of the experience of justice from the judge's perspective, and also some others' perspectives as well. But I'm conscious of the time, and I hope there are going to be questions from members of the audience. So rather than me monopolising the rest of the hour, let me open it up to members of the audience. So anybody got any questions for Sheila? Yeah.
Here you go.
No, we'll stop. You start there.
Thanks, Shailesh, for being with me. I have two questions. I'm not a legal scholar, anthropologist. I was wondering, one, in terms of, how delicate your research is. more sort of a personal reflection on how did you do this kind of research in India, which deals with sexual violence against children. So if you could reflect a bit on how did you undertake the research? And second is more kind of an inquiry. If did you notice if the separate room for child, what kind of conversation? There should have been some conversation in architecture design, right? In designing the separate room for the child. And I was thinking if it's informed, what kind of discussions have taken in designing the courtroom in a way that it's done now?
Yeah, thanks so much. So regarding the first question, I'd say biggest challenge that I had was, and one of the limitations was, of course, that I did not have to access children in a way because they were not my part of the study. So children were not part of the study, but then access challenge was a big one because especially the way Indian judicial system and the trial judges or district court judges work, it's a very hierarchical system. So as often as you might see, let's say, an appellate court judge willing to give you interview and be on the stage and platforms, the trial court judge is very scared of saying anything or sharing anything. So biggest challenge was making them or convincing them to talk about their experiences and challenges. Second, there was no formal process. I did try, but I was aware because I did know from the past research works that usually formal access or permissions are not granted by the high courts. So for accessing trial courts or trial court judges, you do need kind of, let's say, that's the usual route to go through the high court. But then that's not done. Usually they don't give access. And then for researchers like us, the only alternative is to do it informally. So going there and trying to talk to them. And it's like a snowballing process as well, the method that I use, which is, okay, I talk to one, if they agreed, well and good. If they didn't, then I also ask them, okay, could you refer to your colleague who might be interested? And of course, it's, as you'd imagine, it's very challenging to kind of convince them to speak. And also, in most cases, especially when it came to judiciary or judicial officers, I think barring very few, none of them allowed me to record it. So all the times I had to have my hand notes done. And also, I think it is emotionally kind of really heavy as well, especially when I was doing observations, because I literally, thankfully, I got the permission because these are in-camera trials, so you do not have permission as an audience member. But then I did secure it through the judges, and I did sit through the trial, several trials in those two locations. And you can imagine, especially when you see an incident like a child fainting right in front of you, it's really troubling. And then also there were instances, of course I wouldn't want to get into the detail of it right now, but then another instance I can share is when a police officer and a doctor was being examined by the public prosecutor and the defense lawyer, you had this child who was sitting behind, literally shouting from there because she clearly thought that what the police officer and the doctor is saying is not true. And this is happening in the large court. So these are, I think, was challenging in that way. Now, coming to your second question, sorry.
Which was the separate.
Yeah, so I think what went behind that, because there's no law, POCSO law clearly doesn't say anything about that, this organization and all. I think what's driving these is there were several cases in 90s and 2000s coming from the appellate courts, particularly I think Shiba, Bidi, and there are several other cases that I mentioned in my thesis, which where actually there were judicial guidelines as to what can be done to improve the experience of child witnesses in the criminal process. How can it be made more, let's say, as I said, healing, but more than that, because of course that's a really big and far objective, the more than that, how can they be shielded from, let's say, lawyers and judges and accused persons especially. So having separate entrances, having separate room, let's say even in relation to police officers. So say, for example, when police officers have to approach them, they don't need to be in their dress. Though, on the other hand, there's no mentioning in the law of what the judges or the lawyers will wear if the child is appearing in court, like in Bihar. So again, I think it's more kind of informal, but then I'm sure there have been judicial guidelines, and then based on that, discussions among appellate judges in high courts and Supreme Court, which led to these kind of changes. And as you can see, this started from Delhi, being the capital city, but it's not that much in Bihar and other cities.
Just to go back to the research ethics question in the judiciary, you did have protocols for approaching judges and what you would tell them and explain about the research you were doing.
So it's not a formal process. It's not like, say, written that, okay, you have to do that.
No, but you did have that in your research protocol, am I right?
Yes, so I did approach.
Yeah.
But then, as I said, in the past as well, there has been instances where that was denied, and the researchers have then relied on informal kind of permission from the trial judges, right, district judges, and that's the only option left for me, and I had to rely on that.
Okay. We had another question in front.
Sure. So it sounds to me like in the trial process, judges end up playing what was almost an inquisitorial justice role, where they were the persons putting questions, even if they were only taking questions from that were offered to them. Now, I wonder how this plays out in a system that is basically an adversarial system, especially when trial processes have to interact with downstream appeals processes, which are definitely not inquisitorial, as far as I understand. Did you have any insights about that?
I think going back to the point of, and this is something that I think in certain situations made the defense counsels uncomfortable as well as the judges. But then, as you can see, that the law says that both the lawyers from both sides actually will have to produce questions. So they will have option to give questions to the judges. Right? In terms of cross-examining the child, now again, you can put forth those questions to the judges. You can't put it directly to the child. And in certain instances, when the defense counsels felt, and this is what I got from interviewing defense counsels, where they said that it seems that the judges have preconceived notions about the accused being the offender or the perpetrator. And this was also reflected in, let's say, in the bail stages or in bail petitions as well. So that was my finding.
Turning back to the judges, how do you end up being a POCSO judge? Are these regular district court judges who get seconded on this part of their routine? Are they special judges?
Okay, so the way the lower judiciary, let's say the district judiciary and then district judiciary works is you have two ways of getting in. One is you have a degree, law degree, and then you give the exam, and you enter from the judicial magistrate level, and then you go up to the district judge level. You have another one, which is you practice for certain years as a lawyer in district courts, and then you appear for the additional district judge's exam, where you can directly get to become an additional district judge or district judge then after promotion. So there are these two groups. Now, in terms of who are these special judges, these are not special judges as in they are not specially hired to deal with POCSO cases or child sexual abuse cases. So what has been done in practice is that, especially as I found then, was that any judge who was after the rank of the district judge, so it's called additional district judge 1. So all additional district judges 1 were automatically made POCSO judges or special judges to deal with POCSO cases. Of course, there was provision that because they are now dealing with child sexual abuse cases or POCSO cases, they have to be given special training. But as my findings suggest, that wasn't the case 100%. And there were certain instances when the judges said, as I said earlier, they trained themselves by watching maybe a movie or by talking to the colleagues, and proper formal training was not given to all of them. And yeah, so that is.
So is it, did you gain any insight as to whether this was something that a role that judges aspired to and wanted, or was it something, was it seen as prestigious, or was it seen as something you had to do?
I would rather say that I did find one just saying the opposite. So this was a male judge who was in Delhi. And when I was talking to him, he was, and this was, again, came as a bit of shock to me. He said, why do we need to give preference to child sexual abuse cases? What's so special about it? And then he goes on to say that I have been made a special judge to deal with these cases. In a couple of years, I'll forget the details, so let's say the procedures and other things about other cases. So don't we think that murder cases are important? So that was the understanding of that judge who did not consider child sexual abuse cases as important and was actually, I think, not happy with his position being of a POCSO special judge. Because as I said, I don't think that judges are asked if you want to become one. It's more sort of if you are at this position, automatically you will be drafted as
And you
one
did
of the
that
judges.
time.
Full time. Because it's a specialized kind of position, so you don't deal with any other cases then. Though, of course, in the past, when this started, initially because of, and this is the workload issue, when they had to deal with several other cases as well, along with the POCSO cases. And that was a big problem for them in terms of workload. But then gradually, I think, because of getting more and more judicial infrastructure and judges, they are now dealing only with POCSO.
During your research process, did you have a questionnaire for the judges? What kind of questions did you ask?
Yes, indeed I had. So I prepared an interview schedule, a questionnaire, and I had the questionnaire also targeted to specific groups of respondents. Of course, I had, though of course mostly it was similar, but then there were a few amendments and changes to those questions. So when I'm asking, let's say, questions to a judge, in comparison to when I'm asking a question to a judicial magistrate or a public prosecutor or a police officer, there were slight changes in the questionnaire.
And what's the hierarchy of the courts? When you say district, is it high court?
No, so it's kind of similar to here. It's just that, let's say you have the Supreme Court, then you have the high courts at different, so one Supreme Court in Delhi, which is the highest court, like you have the UK Supreme Court here. Then you have the high courts in different states, so that's after the Supreme Court. And then after the high court for criminal cases, you have the district judges court, which is also known as the sessions courts. And that's where usually these cases are dealt with. But then below that, you have the additional district judges court, chief judicial magistrate, and then lowest level, you have the judicial magistrate.
So when you were giving the statistics, you say over time it's now about 10% of the cases that have been finalized at the end of the year.
Only 10%, yeah. So the rest 90% carry forward.
So what is happening? Because it's been since this is 2012 when the act was came into place. What is maybe 10% is an improvement, but what do you think is causing the drag in determination of cases? Because it's quite some time.
I would say several factors because, like any criminal justice system, I think Indian criminal justice system also, you can imagine like an octopus with several limbs. So it's like traditionally just one part of it. You have the medical side of it. You have the police side of it, who does the investigation, who have to bring the accused and the witnesses. You have then, let's say, the lawyer side of it. So defense counsel wanting to delay or wanting to compromise, let's say, as is done in most of the cases in the Indian context, because there's this kind of legal pluralistic framework also that works in the Indian context. Because especially if it's in, let's say, small towns or villages, what happens in these cases, and there's a really excellent film that has come recently, and I would recommend if you're interested, you can watch the story, To Kill a Tiger. So it'll show you, and that's what I found in some cases in my fieldwork as well, that the community where, let's say, you have a village or a small town where, let's say, a child sexual abuse incident took place, right? Now, the understanding or the perception is that this should not go to the police. We should be dealing with ourselves. But then, in dealing with ourselves, the idea is that it becomes kind of injustice to the victim and it's more pro-accused or let's say offender. Why? Because they say that, okay, it was a mistake and we can't ruin the life of this boy for, like can't imprison the boy for a lifetime of 25 years or so. So an alternative that's usually proposed is in such cases that, oh, why don't you two marry each other? Because anyway now you have been so-called, let's say, violated or polluted, or let's say you have lost your virginity, no one will be marrying you. So let the perpetrator marry you. And that way we can protect the honor and dignity of your family, of his family, and of the community and villages.
So what is your conclusion? Has the act been efficacious in achieving what set out?
I'd say to a certain extent, but then there is a lot of difference between the locations. And this is another, I think, important part of doing empirical legal research that brings to light that when we look at just one, especially a capital or a metro city, that doesn't tell us the correct story of the entire country. And that was the reason why I chose these two different locations, which kind of clearly suggests that where Delhi, being the capital city, is kind of much more ahead in terms of, let's say, holding them accountable, these stakeholders, as well as the kind of infrastructure that's available and the kind of support that's given to the child survivors, sexual abuse survivors and their families. Whereas on the other hand, in Bihar, there was a big lack of all of these. So I would be hopeful and can only say, being an optimistic person, that going forward, things will change gradually. But again, that won't only need something from the stakeholder side, but also several changes in substantive law, in procedural law, and also especially the mindset. So something around the sensitization of the general members of the public about child sexual abuse. And as I said at the beginning, it's a global epidemic. People don't want to talk about that. They don't want to acknowledge that this has happened. And another very interesting finding was that 95, or let's say 99% of cases that I observed, you would see that all of them involved people from really, really poor background. So very socioeconomically marginalized. Now that clearly suggests that, okay, that means that child sexual abuse takes place only in poor families. But then we also have accounts of survivors in India or from India, which suggests that no, it happens in middle class, upper class families as well. But then where are those cases? And that clearly suggests that those survivors are not coming forward.
Okay, well, there's no shortage of questions and lots of issues to be explored, but I'm going to draw it to a close in this forum and invite you to join us for light refreshments just down the corridor, where you can continue to ask these very searching and pertinent questions. And English will inform you of the findings of his research. But before we do that, I'd just like to say thank you, Shailesh, for an interesting presentation. It's an amazing project.
Thanks so much for inviting me to the opportunity, and ILS and Carl. Thank you so much. And this has been a wonderful experience. And thanks to the audience. Thanks so much for coming.